Hello, I'm David DeWolf, and I'm a candidate for Position 1 on the State Supreme Court. This is the third of 4 videos that explain what is at stake in this election, a choice between a court that respects your rights and one that has replaced your rights with its own idea of how you should live. This video describes how the court decided to hold the state in contempt. In the first 2 videos, I explained that our state constitution promises a government that exists to protect and maintain individual rights, and how the McCleary case has taken that principle and turned it upside down. According to McCleary, the most important right contained in the Constitution is what they call a positive right to education, one that permits the court to compel the government to act in a way that satisfies the court's definition of what constitutes ample provision for education. I showed how the court's interpretation of Article 9, Section 1 is implausible, even absurd. But in this video, I want to focus on the remedy that the court is pursuing. Remember that the court has held the entire state in contempt. They've imposed a $100,000 per day fine, and they have scheduled a hearing for September 7, in which they threaten to take even more drastic action. The McCleary case started in 2007 with some parents suing on behalf of their children, claiming that the state was violating their constitutional rights. The trial judge held a trial that lasted almost 3 months, with over 50 witnesses and over 500 exhibits. In other words, this trial judge took it upon himself, after listening to various witnesses describing the way in which education had been funded, to do what our Constitution expects the legislature and the governor to do, to decide how your tax dollars will be spent. Our state constitution provides a way for decisions to be made about taxing and spending, the budget-making process. They made it the job of the legislature, where our elected representatives would agree to a budget and then submit it to the governor for approval. Is this a divinely inspired process? Of course not. Democracy isn't always pretty. Democracy, as Winston Churchill pointed out, is the worst of all forms of government, except for all the others. A courtroom trial, by contrast, is much more orderly. A trial judge could schedule witnesses and read documents, and after careful consideration, decide how much of our tax dollars should be spent on education. That would save our legislators and governor a lot of time, but it isn't the government we signed up for. The principle of no taxation without representation, a principle our nation's founders risked their lives for, is based on the idea that any burdens placed on the people should be put there by the people themselves through their elected representatives, who would be accountable for their decision-making in the next election. In the previous 2 videos, I explained how absurd it is to suggest that when our Constitution was written, our state's founders wanted the courts to be in charge of reviewing the state budget to see whether it was to their liking. But there are new reasons to think that the court has gone terribly, terribly wrong. According to McCleary, the so-called positive right to an amply funded education was an appropriate thing for a trial judge to decide, as though it were an intersection collision case or a medical malpractice case, in which you listen to witnesses and make a decision. Many of you watching this video have served on a jury, or you've watched a trial on TV. You know that we have juries, or in this case a trial judge, to decide the facts in a case. Was the light red or was the light green? Did the doctor follow the standard of care, or did he commit malpractice? And once the jury, or in this case the judge, makes a decision, the appellate courts treat that decision with respect, the same respect we give to the home plate umpire who calls balls and strikes. If you watch a replay and think the umpire got it wrong, you still accept the fact that there's no review. The home plate umpire has to have the authority to make the call. In a similar way, an appellate court reviews the decisions of a trial court in an intersection collision case or a medical malpractice case with similar deference. All the appellate court asks is whether there was substantial evidence to support the trial court's decision. It doesn't matter whether the appellate court thinks the trial court reached the wrong decision on the facts. But how can you apply a similar rule to the enforcement of this so-called positive right to an amply funded education? The trial court literally put the entire state on trial. And when he claimed for himself the authority to decide what constitutes education, or whether or not the provision for education was ample enough, he not only usurped the power granted to the legislature and the governor, but he also displaced the right that you and I have to decide what taxes we are going to pay and how those tax dollars are going to be spent. So the court in McCleary applied a substantial evidence standard to the trial court's findings. So what this means is that the McCleary case is not a one-shot deal. If the Supreme Court meant what it said in McCleary, we should brace ourselves for permanent review by the courts of the education budget. Many people who don't like McCleary and resent the court's overstepping its constitutional authority have nonetheless shrugged their shoulders and said, let's not fight about it. Let's just find a way to increase the funding for education and be done with it. Otherwise, there's no telling what might happen. But it's not that easy. This isn't a one-time fix. If in 2017 the legislature and the governor agreed on a budget that completely satisfied the Supreme Court, a new set of parents could walk into court the next day and claim that their positive right to an education wasn't being honored. A sympathetic trial judge could start the process all over again. In fact, according to the Supreme Court, that's what he or she would be obligated to do. Maybe a future court would at last realize that it couldn't live with the absurd conclusion to which its language in McCleary would lead. But do we have to wait that long? But I have even more bad news. Whether you like or dislike a court's ruling in a particular case, we expect a court decision to be final. And since most decisions produce at least one loser, courts are used to dealing with people who don't think that justice has been done and then don't want to obey the court's ruling. In an ordinary case, if you disobey a restraining order to stay away from your ex-spouse, you can be fined or even sent to jail for contempt. If you don't pay a judgment entered against you, the sheriff can come and seize your property to pay the judgment. So in this case, the court thought that its ruling should be treated as final, and whether they liked it or not, the legislature and the governor simply had to do what they were told. But it's not so simple. If the court were really dealing with a deadbeat dad, they would have the resources to make the defendant obey. You can just ratchet up the punishment until the loser cries uncle. But the state isn't a deadbeat dad. And that takes me to the final video in this series, A Court That Knows No Limits. I hope you've learned about our Supreme Court and what's at stake in November's election. Please log on to my website, DeWolfforJustice.org, and tune in for Part 4 of this series, A Court That Knows No Limits. I'm David DeWolf. Thanks for watching.